Hello, I'm April Jones, and we at Jones Law Firm care about you, your family, and your well-being. That's why we've put together this informative webinar series to answer your questions about life, about the law, about your family. So thank you for joining us, and let's get started. Hi, I'm April Jones. We are Jones Law Firm PC attorneys, and we are happy to welcome you to our webinar. Today's topic is relocation. So if you're dealing with child custody, you have a child, you want to move outside the state of Colorado, and your ex doesn't want you to, that's when you need to talk about a relocation case. So we're really excited to be here today. We've been in Colorado for 21 years. So we're really excited about that. We're like 20 employees, 21 years. We do family law all day, every day. We help breaking families divide money, property, and children, and we are really good at it. Today I have my senior attorneys with me, David Collins and Nikki, and I will have them introduce themselves directly, and then we will jump right to questions so we can make the most of our time today.
Yeah, good afternoon, everybody. I'm Dave Collins, senior attorney at the firm, doing all things family law, including divorce, parenting, time allocation, child support, maintenance, adoption, guardianship, and a big part of my practice involves parties where one parent is relocating or has relocated to another state. So I look forward to talking with you today.
And I'm Nikki Van Getz. I'm also a senior attorney at the Jones Law Firm. I've been practicing family law exclusively coming on 5 years now. So unfortunately, with the pandemic, we're seeing a lot of shifts in people's housing situations. And so relocation has become something that's become more and more frequent in our practice. So we do have quite a bit of experience in dealing with this issue.
All right, so let's just go ahead and jump in. I'm looking at some of the questions we have here. And can relocation be decided as part of an initial custody determination? Well, technically, if it is an initial custody determination, it is not a relocation because there were never court orders locating you your parenting time will be in Colorado. You don't have the initial orders locating you in the first place. But when the court is making a determination about parenting time, it will review some of the same statutory criteria in making that initial parenting time determination, which is what you would be referring to as a relocation. David, do you want to elaborate on that?
Sure, and just to expand on what April was saying, in Colorado, if you already have parenting time orders and you want to relocate, there's a statute dedicated to that, and there are standards the court has to follow. As April was mentioning, this question asks the question, what if I want to relocate before there are any permanent orders? Maybe we just filed a case. In that case, either the parties can agree to a two-state parenting plan, or the parties can ask the court to fashion one, as April was saying. If you've never had a proceeding and you've just filed a case and one party wants to live in another state and the parties don't agree, then the court will end up entering an order for what is a two-state parenting plan.
Now, one thing David just said that is a nuanced point that that question didn't ask directly, but is really relevant, is if you've already filed in Colorado and you want to move to a different state, even though the court hasn't issued orders about your final orders in terms of where you will finally be able to parent, once you've done your initial filing, you are served with automatic injunction. And that automatic injunction limits you being able to live outside of the state with your child or leave the state with your child. You're restrained from leaving the state of Colorado without permission of the court, permission of the party, or order of court. So you are still limited. And that's in a case, even if you're not asking to have your parenting time, you're not asking to relocate, you're just asking for the court to issue parenting orders, custody orders initially, you will have that automatic injunction, which prevents you from leaving the state with the child. And that includes Disneyland. But if you want to go to Disneyland, we will ask the court in an initial status conference or file something and say, hey, they're only trying to go to California for Disneyland, and 9 out of 10 times the court will grant that. Everybody agree? Anybody want to add anything? All right.
I didn't want people out there to think, oh no, I can never go to Disneyland once I file. At least just have a hoop to be able to jump that you have to jump through before you can go. Next question. What if I or my spouse leave Colorado before filing for divorce? Nikki.
So this can be a complicated situation because you are free constitutionally to relocate or move anywhere that you want at any time. Where the nuance falls in is when you want to take your children with you. Prior to anything being filed with the court, you're free. There's nothing preventing you from being able to take your children out of state, but that's not to say that it wouldn't impact a potential child custody or divorce case moving forward. If you were to relocate or move with your children, take them with you, and then and Colorado still has jurisdiction over the case, and the other party moves for either a child custody case or a divorce case, you're going to run into a couple of issues where the court is going to look at what is the best interest of the children, the best interest of the child associated with that move. Is that something that was child focused, or is that a decision that was made for more selfish intent? That sort of thing. And has that person who's moved taken into consideration the impact that that's going to have on the child and their relationship with the other parent, those sorts of things. And so while there's nothing explicitly prohibiting you from doing it, if in the event that a case does get filed, it could turn out not to be the best look for you based on your motivating factors and kind of the communication that you've had with that other parent about that decision to move with the children.
Absolutely. I was just having a conversation at the gym this morning with someone who was talking about what would be an exception to what Nikki's talking about. And it is the 180-day jurisdiction rule situation. So the conversation had to do with moving. Someone had taken the child out of state with permission and then said, oh, just give it, this was an ex-girlfriend, give me 6 months to think about it. Like, just let me think about it. I just need to spend time with my mom in the state where she lives with my whole entire family and think about it. So, and it was after 180 days. So he's talking to me and I'm like, the jurisdiction is no longer with the state of Colorado if your children have been outside of our state, living in another state exclusively for over 6 months. So that's something that's important to know if you think you might have that sort of a situation. So it's a timing issue if you're going to move out of the state prior to filing, because if you haven't filed, move out, be gone for 6 months, and the other state would, Colorado would lose jurisdiction potentially of the children if the children had not resided here, even if one parent remained here. David, do you want to elaborate on that? Because we get that a lot.
No, I think you guys covered that pretty well.
Okay. Nikki, anything else you want to add and follow up?
No, I think that's exactly right. The jurisdictional issue, again, with that 180 days, obviously, if you think that, perhaps you are moving to a state that could have laws that could be advantageous to you, you might want to consult with somebody there if a case isn't going to be, if you're confident that a case wouldn't be filed here before 6 months is up of having made that move.
Yes. And if someone is telling you, just give me a couple months, don't give them a couple months without checking on your legal rights. Even if it's only been 150 days instead of 180, the court could say, you know what, I'm going to talk to the other court. You file in Colorado, you say it's only been 160 days, Your Honor, hasn't been 180. They could say, well, let me talk to the judge in the other state and decide if the judge in the other state can best handle the case. And then the children we still can't get the children brought back to Colorado. So sooner is better if you're looking to assert your rights and keep jurisdiction here. Next question. 2-state parenting plans. Are these a good idea? What's a 2-state parenting plan, David?
So the answer is, it's up to you whether a 2-state parenting plan is a good idea. They're extremely common. So our practice always has cases involving one party who is leaving Colorado. And so I think that the question to answer is, what is a two-state parenting plan? By law, the court in Colorado, if a parent indicates they're going to reside in another state, the court must fashion a plan for parenting to exist and occur across state lines. What that really means is that one parent will be the primary parent, and one parent will be the summer and holiday parent. And so what that means is, in the United States, everybody has to go to school. And so the court is going to order that the child go to school in one state, not two states. And school runs from September to May every year. In Colorado, it's August to May. And so from August to May, the child is going to reside primarily in let's say Colorado, if Colorado is the state that for the primary parent. It could be that the parent that left Colorado and is now in Florida is the primary parent, and they go to school in Florida from August to September. The parent that does not have school year parenting time is then seeking expansive amounts of time when school is not in session. That includes the 8 to 12 weeks of summer, depends on your school and your school district, how many weeks of summer you have. But the parent who is not primary parent is usually advocating for most, if not all, of summer. There are also a lot of school holidays that occur, and it really depends on your district. Here in Colorado, if you compare Douglas County schools here to a school in Illinois, you might find that the school in Illinois has a solid week of vacation in October and a solid week of vacation in March, and those don't exist in Colorado schools. So really, the school will play a factor. But what the parent who's going to have the child as a non-primary parent needs to do is get a copy of the school calendar for the school the child's attending and find all the holidays. The court is likely to award that parent parenting time for 3-day weekends, 4-day weekends, and any school holiday that exceeds 4 days. And that's usually at least Thanksgiving, Christmas, and Easter. And then some districts will have more holidays. The other option for the non-primary parent is to also exercise parenting time in the state of the other parent. So a lot of times the court will say, yes, Dad, you're in Colorado, the child's primarily living in Texas, but you're going to get Christmas, you're going to get a big chunk of summer, but you can also travel to mom's home state once a month and have a weekend with your child. And so to the degree that a party can afford the travel, often a court will allow that parent to have some amount of parenting time in the home state of the other parent.
And a lot depends on the age of the child's ability, a 2-year-old flying back and forth, a 1-year-old flying back and forth versus a 12 or 15-year-old, right? By the time they're 16, they think they can fly the plane. So a lot of it gets nuanced. What David was saying will vary within all that based on the age of the child, the ability to parent of the two parents. Like if one parent is not really good at having the child do their homework, not really invested in school, then they potentially may not be the parent that's chosen to be the school year parent. And that could mean the child's in school and, out of state somewhere instead of here, and vice versa. So the court does look into a number of factors in making that decision. I had a judge tell me that is one of the hardest decisions she ever has to make. And I said, well, what about, abuse cases? What about these other, really complex and sometimes horrible cases? And she said, those are what they are. But when you're choosing between two good parents and you're going to end up making a ruling that one really good parent doesn't get to see their kid, that's just hard. And that's just something that sticks with her when she's doing her job. So that's an important thing to think about. Like one parent who's an invested parent is not going to have the bulk of the school year with the child, but they could get the entire summer. I mean, some orders for summer are the day school is out to the day school returns, and you could pack a lot in an entire all day, every day summer, plus 3 and 4 day weekend, plus, as David was saying, if you can get to see your child because you can afford to fly to them. So that's a lot of detail. If you are in that situation, you really need to talk to an attorney. The statute is long. It's like 21, 22 factors for relocation, plus anything else the court chooses to consider. And you need an attorney because it's an important decision and it could go all different sorts of ways if you don't know what you're doing. So definitely we're denverdivorceattorneys.com. If you need to talk to someone, please give us a call. If you know someone else who needs to talk to someone, like a friend, a neighbor, a colleague, send them our way and we can help them walk through this, because it's scary. The thought of not, seeing your children as often as you're used to is scary. Next question.
Hey, April, there was a good question in the chat.
Sure, take it.
So the question in the chat was, if the child's 13 years or older, can they choose who they live with? And the answer is no in Colorado. Other states do have laws that allow a child to choose after a certain age. In Colorado, it is one of the factors of the best interest of the child factors. April was describing that there are many factors the court must apply to decide relocation. Those include all of the state's best interest of the child factors. One of those is that if the child is sufficiently mature to contribute a position, they can, but it won't be the deciding factor. And it's also pretty clear to me after practicing family law for years that the age of the child is not necessarily the indicator of maturity. It can be, sort of presumed that they're mature after a certain age, but a lot of times the individual child is nowhere near mature enough, even at age 14, 15, 16, to contribute to a decision that the judge will make. And that's based on testimony of the parties about the child and the maturity level of the child involved. So it's not a guarantee, even that as they get older, that their wishes will be factored in unless the court decides they're really mature enough to weigh in and offer a perspective about where they want to live.
Another way that I like to explain it is, when would you let your child babysit? Oh, no, stay home alone. Stay home alone. When would you let your child stay home alone? Would you let your 10-year-old stay home alone when you went next door to get a cup of sugar, if people still bake? Or would you let your 13-year-old stay home, and how long? Will you let your 16-year-old stay home? Some you'd never let your 16-year-old stay home because of the type of, because of what they might do. So that gives parents kind of a real world way to assess their children and their children's maturity. And as a parent, you see how you adjust it based on your individual child. So you get a typical 16-year-old who's mature enough to make decisions and has an opinion. The court will listen to those opinions. You get one who wants to stay with dad because he likes to get high with dad's girlfriend, and he likes to not do his homework because he has to do nothing over there but like get high and not do homework. The 16-year-old, the age itself is not going to carry the day. We certainly hope it's not. But a 13-year-old is certainly a more mature person, generally speaking, than like a 4, 5, or 6-year-old. And that child's wishes will be taken into consideration. But as David says, whether or not it'll carry the day depends on the circumstances, depends on your facts, depends on the reasoning, and it depends on the court. Some courts are ready to rubber stamp, an older child saying something. And then some courts are like, I don't care if you're 16. I mean, that I think is the more the exception, but that's the situation. Is it varies, and you need good counsel to get in there and make the argument for your case, depending on what you want that argument to be, for the maturity or the lack of maturity, and for the circumstances that give rise to why this is in the best interest of the child or not. So these aren't things that are done lightly, and you need somebody experienced on your side. denverdivorceattorneys.com. If that's a situation you're in, you should just reach out to us right now. Thank you, David.
Sure.
Could relocation result in a change of custody? That's a good one. Nikki.
Yeah, absolutely. It definitely can. If there's a relocation, there's already orders in place. Typically, for example, if you have orders in place that consider two parents who are going to be in Colorado, say, for example, you have a 50-50 parenting plan. If there's going to be a relocation that occurs where one parent, either you or the other parent, is relocating out of state, that does require new orders to be put into place, and the court needs to be able to review that and accept either an agreement or enter orders regarding that relocation. And as David and April had been mentioning, there's not an easy way to try to keep a 50-50 parenting plan in place when you are going to have a 2-state parenting plan. And so that is going to require reconsideration of what the parenting time situation and setup looks like. So even previously, if there have been equal parenting time orders, someone is going to have to become the primary parent that does have the majority of parenting time. That being said, even if there isn't a completely equal 50-50 parenting time in place, a relocation is something that is such a substantial change in circumstances for a kid that even if one parent does have majority parenting time with both parents in Colorado, a relocation could kind of flip that on its head to where perhaps if the primary parent here in Colorado wants to relocate, say, to Hawaii, that's going to be a huge change. And so the court is going to want to review all of those factors dealing with the relocation statute to consider each of the
Sorry to
parents'
interrupt,
thoughts,
but you have an appointment soon.
each of the parents' thoughts, the kids' input, the reason for the relocation, the reason for objecting to the relocation. And it could very well be the case that primary parent ends up being flip-flopped altogether. And so it's really just, it's going to require a deep and thorough assessment as to all these different factors that interplay with one another in order to figure out ultimately what is going to provide this child with the most stability and what's going to be in their best interests. So it is a very kind of thorough analysis that needs to take place. And it could end up being a completely different parenting plan that results because of a relocation. So it's something that you don't want to consider lightly.
Thank you, Nikki. Here's one in the chat. And by the way, I didn't announce this at the beginning, but this is typical of our webinars. Please put your questions in the chat. We will answer them real time as we have time. Do you want to take the chat question, David?
Sure, I just need to open up the chat, sorry. And I opened up the wrong chat. Let's see. I only see, oh, what should I do if my ex-boyfriend moved without? So the question is, what should I do if my ex-boyfriend moved without notifying the court? What's missing from this question is, did they move with the children? So let me answer the question both ways. So if you're the mom and you're in Colorado and the children are with you and he left the state, you don't have to do anything. If you don't currently have parenting time orders, it's always a good idea to get some so that you have some formality to how you're going to have parenting time with the other parent, even if they're staying in Colorado. But if dad has left the state and you're concerned about dad coming back and removing the children from the state, you really want to make the case a Colorado case by filing here. Colorado has jurisdiction over the case if the child has been in Colorado for the last 6 months, and it has jurisdiction over the parents for the same reason. Now, if you've never had a custody case and both parents were living in Colorado and dad just took the child and left the state, you can file with the court a series of filings to get the child brought back and for the case to be adjudicated in Colorado. So I think part of the question we're being asked here is, if dad just leaves Colorado with the children to New Mexico, can he just file in New Mexico and suddenly I have a case in New Mexico? And the answer is no. You have to act, the child has to, the state has to be the home state of the child. And for that to occur, the child has to live there for 6 months. So even if a parent takes the children out of Colorado, there's never been a court order, the parent still here can initiate a case in Colorado and then file something with the court, likely a Child Abduction Prevention Act motion to compel the father to bring the child back to Colorado. And this is not uncommon, and the courts do this. They will order a parent to bring a child back to the state of Colorado until the court has issued orders regarding what the future of parenting time is going to be.
That is, thank you, David. One thing I would add is, and we have this in some of our cases together, if the child hasn't been alive 6 months, where's jurisdiction? It's where the child is born. The state where the child is born. Just in case whoever asked this question is asking about a younger than 6-month-old child. Okay, here is a question. What do I do if my children are going to leave? Well, I'm going to assume some things with that question. I'm assuming that you've got a court order and your children are leaving because the court order is that they can relocate to another state, and you are the minority parenting parent because they're school-age children and you're only getting some version of summer and holidays. I have had people move to the other state where the children are being able to relocate to and get a job there, live there, and now they're back to their normal 50-50 parenting schedule. So I've seen people do that. I've had a client who just moved wherever mom moved. That historically hasn't been practical, but in our virtual world, that's something you could consider if it's just, you just can't take it, like you can't, this is just too hard to see your children in this limited schedule. If you've got a court that will say, yes, if you're both in the same state, then you keep your normal parenting schedule, then that's a way to get around it. Anybody want to add anything else to that?
That sounds about right.
Okay. And what is the likelihood that the court will or will not allow my ex to move with the children? Nikki.
That's a tough one to be able, because again, it all depends. It depends. Is there already an order in place, or are we talking about a relocation taking place after existing orders? And that's going to impact the series of factors that the court would consider. They're always going to be looking at the best interest of the children, but are they going to be looking at all of the relocation factors or not? And that all depends on the timing as to whether or not you already have orders in place. Generally speaking, it is an uphill battle for the relocating parent to try to become the majority parent, especially if a child has been in Colorado and established this as their home. The longer that that's been in place, the tougher that it can be to uproot them from that environment and then reestablish them elsewhere. So, there's always going to be exceptions to that, especially, they'll take into consideration, for example, where does extended family happen? How close are the bonds to that family? What does the new school situation look like? What's the reason for leaving? All these things play factors in it, but generally speaking, relocation is going to be a pretty tough battle. It's going to be an uphill battle for the person wanting to uproot the child from where they've known and where they've been comfortable and kind of establish themselves.
And that's, of course, assuming we've got two fit and proper parents, right, Nikki? Like if one person is been absent, is an unfit parent, doesn't see the child, and you want to move, that's obviously
different analysis altogether.
But we do have a chat question. If I take a child out of state, will I have to go to court to modify my parenting order since I have the child most of the time? David.
So that's a good question. And I don't mean to correct you because you're my boss, but I think they said because I got a job out of state, so I'm going to move. And the answer is you still have to get a court order. So if both parents are in Colorado, let's say your parenting plan is 5 years old. You went to court 5 years ago. You've been co-parenting ever since. One parent has 80% of the parenting time. The other has 20%. The parent with 80% of the parenting time still can't move out of state with the child without a court order. So it's still a relocation. You'd still have to go through the legal process. If you leave the state with that child, they can force you back and have the court decide whether it's in the child's best interest. And there are, just to go over some of the factors that are really important here. If the child has significant maternal and paternal family in Colorado, that's going to weigh in favor of the parent staying in Colorado. If they have significant friendships and peer groups, if they're deeply entrenched in the school here and they've maybe been on their soccer team for years and they've seen the same therapist for years, the message I'm sending you is that a relocation determination by a judge is really a sum of many parts. There's no one reason that the judge is going to rule in favor of one parent over the other. It's going to be a compilation of a lot of little pieces of information that help the judge make what is, and April said this, a very difficult decision for the judge. The law says they have to enter a two-state order. They don't have a choice if one parent's moving. The parent who's moving doesn't have to justify it. You don't have to have a reason. You can just say you're moving and the court has to honor it. And then the court has to fashion a two-state plan. So the question is, what's in the best interest of the child? What will have the least negative impact on the child from this, which is already going to be, a difficult thing for the child to have parents in 2 states.
Which kind of dovetails. We also have a question that says, does why I'm moving matter? And that is one of the criteria. David mentioned, a few of them, but there are 21 plus the other statutes. So one of them is, why are you moving? And does it matter? Yes, it's one of the criteria that the court's looking at. So you're moving for your job. Are you moving because you're in the military? Are you moving because there's nobody here to help you at all with your child and all your family is in another state and, dad's useless? Like, why you're moving does matter, and it is one of the factors. Now, one thing that I do like to remind people, that you get caught up in a relocation, like I'm losing my child or I'm not losing my child. It's really only a question of who has a child during the school year and who has a child during the summer. And that's when you have 2 children and when your children are in school. If they're not in school, then you're looking at how do we fashion a plan with this preschool age child that makes sense and is in their best interest in terms of what's involved in travel and that sort of thing. So big decisions, hard decisions. If you want to get in there and relocate and you are the 80% parent or you are the 90% parent, you still do need to file your motion. Think about it this way. The way the court's looking at it, this 80% parent who has every Saturday overnight, every other Saturday overnight is going to lose that. And in order for you to take that away from that person, you need a court order to do it. So is it easier when they have less time? Possibly, likely, but there's always exceptions. So you need an attorney to really handle a relocation for you. This is not an area that I suggest people handle pro se because it's too important and you have too much to win and too much to lose in terms of your family. And that's what we're talking about right now is just your family and how we can help you get to, the next better situation for yourself, given the factors of your case. So we are out of time, but thank you so much for joining us. We appreciate you. We appreciate your referrals. Thank you for the trust you put in us. If you're listening for your brother or your sister and you just want to get information. So definitely send them our way. Thank you, David. Thank you, Nikki. And we will see you next time.
Take care.
Thank you.
Bye.
Thank you for joining us for this webinar. If you or someone you know would benefit from watching a recording of this webinar or any of our other webinars, they can be found at denverdivorceattorneys.com. Thank you, and keep a lookout for future live webinars, and I hope to see you again.